Good day, everybody, and welcome to this year's installment of the DMA's National Roadshow, which is obviously quite different to other years in that it's being presented digitally. We trust that you've all made it through the pandemic and that we are ready to enter into the last quarter of 2020. Firstly, I'd like to thank the DMA, Mr. David Dickens and his team for welcoming us to this segment or this installment of the National Roadshow. Today we're going to be speaking briefly with you about what the Direct Marketing Association is doing or has done to assist its members with data protection compliance, as well as who we are as Weavind Online. I will introduce our offering to you, and I will speak a little bit about what the status of the Protection of Personal Information Act is at the moment and what you need to be doing as a responsible party in order to practically comply with this game-changing piece of legislation and what it practically entails from a compliance perspective as well. So firstly, just with regards to who we are, Weavind Online is a legal tech company. We are essentially an alternative legal services provider, and we have partnered with a traditional law firm, Weavind and Weavind Incorporated, which is a traditional law firm based in Pretoria and which has been in business for well over 100 years. We essentially saw an opportunity to change the way in which traditional legal services are rendered, and we have ever since been trying to deliver traditional legal services in innovative ways by leveraging technology, understanding the interface between technology and the law, and assisting our clients with the practical implementation and application of game-changing legislation such as the Protection of Personal Information Act, which obviously has a very strong bearing on businesses and the way in which responsible parties operate and process data. As a part of this segment, what I'm going to be dealing with today is just establishing a practical understanding of what POPI status is at the moment, or POPIA as is the correct reference. Once we understand what the status of the Act is, we can then take practical steps to firstly establish and then maintain compliance with its provisions. So the Protection of Personal Information Act, POPIA, was essentially promulgated in 2014. Its enforcement was essentially extended or delayed. And in 2014, only certain sections of the Act came into force. Specifically, the sections dealing with the definitions, the establishment of the information regulator, the sections dealing with the creation of the regulations, and very recently, at the end of June, the 1st of July 2020, the so-called 8 conditions for lawful processing and the provisions which relate to those conditions were brought into effect. And this has also initiated the so-called window period or grace period dictated in terms of Section 114, which essentially gives responsible parties an opportunity or a period of 1 year within which to comply with the provisions of the Act, at which time or at the expiration of which in 2021 the information regulator would then be in a position to enforce the provisions of the Act. Now, many of our clients have said to us, well, if POPI isn't fully enforced yet, what are we doing? Why are we talking about this? And that I suppose to a certain extent is a valid question. However, the fact that the regulator is not as yet in a position to enforce the Act or to enforce compliance with the Act does not necessarily mean that you shouldn't get your proverbial house in order and start putting in place the necessary measures and take the necessary practical steps in order to comply with this piece of legislation. A period of 1 year isn't very long, and we've really seen that an approach or a journey to compliance is really applicable here, and you need to start in order to ensure that when the time comes in the middle of 2021 that you will be compliant and that your organization, your business as a responsible party has taken the necessary steps towards achieving, firstly establishing compliance and then maintaining compliance on an ongoing, consistent basis. So with that said, the very important thing that we always want to get across to our clients when we embark on a compliance journey and we start assisting them with the necessary legal advisory and support services is we want to assist them to actually understand what the Act means to them, what the Act actually requires of them as a responsible party, and then to equip them with the necessary tools to be able to establish compliance and then thereafter maintain compliance. So that's essentially where the Direct Marketing Association's compliance portal becomes extremely relevant for its members. And I'm going to be speaking about that in a moment. However, before we get to that point, I would like to just deal very briefly with practically what is the next step. We now understand where Poppy is, what its status is at the moment. We know that the information regulator, it's well publicized that the information regulator's office is operational and becoming more operational by the day. We know that data, personal information is an extremely valuable commodity that is worthy of protection, and the rights which the Act wants to promote and protect are essentially fundamental human rights. Our right to privacy, which is entrenched in the Constitution, is an incredibly important fundamental right, and this Act is taking huge or making huge inroads in actually entrenching that right even further and protecting that right from exploitation by responsible parties all across the country and the globe as well. So that said, one of the key questions that we always get asked when we undertake a compliance journey with our clients is, all said and done, the Act provides for the 8 conditions for lawful processing. It essentially sets forth all the requirements which a responsible party needs to comply. But what practically do I need to do as a responsible party? As a company, I'm running my business. What do I need to do? Where do I start? So the purpose of this segment really is to, in a nutshell, give you that information and then show you what the Direct Marketing Association has done in order to assist its members in ultimately achieving compliance. So what do you need to do? The point of departure from our perspective really is, and also to simplify this compliance journey for you, is to have a look at what the Act requires of the information officer, which is required to, it's a portfolio. An information officer is a portfolio that every responsible party is required to give effect to. The default position in terms of PIA as well as Poppy is, the information officer is either the head of that private body or that responsible party. whether it be the managing director, the CEO, the highest office holder within that organization. That is the default position. However, those responsibilities can be delegated to an appropriate level of expertise within the organization. And essentially, the information officer is the champion, the custodian, and the individual who needs to go about establishing a compliance framework for the responsible party, who employs them. So that's really essentially our point of departure always, is to establish firstly our clients' compliance with regards to existing legislation such as PIA. Do you have an information officer appointed? If not, that is the first step. Appoint an information officer, or the default information officer, if you will, is required to then give effect to their duties and responsibilities in terms of the Act, and specifically Regulation 4. So what are these duties? What are these responsibilities? The first step really is for you need to establish a compliance framework. You need to undertake a so-called gap analysis or an internal risk assessment, a needs analysis, to establish, firstly, how do you process data? What data do you process? What type of measures do you already have in place? What does your processing infrastructure look like? And where are your risks? You need to first establish where you stand in order to know what you need to do in order to establish compliance. So that is the first step, to undertake a needs analysis or a risk assessment, and then map your compliance journey accordingly. Practically, what your compliance framework would entail is establishing what is your company or your organization's position with regards to policy. You are required to give effect to a privacy policy. You need to understand where you process the personal information of data subjects, how you process it, and you need to establish when you are required to procure consent in order to process that personal information. And that is really an undertaking which there isn't a one-size-fits-all. It's an undertaking that is very much dependent on how your business operates, how you process data, and that is really going to determine, the outcomes of that process are going to determine how you are going to essentially build your compliance framework and thereafter maintain it from there. Another aspect or another obligation which is really critical and which goes a very long way in terms of understanding where and how this legislation is to apply to you is training and awareness. We encourage all of our clients and the information officers that are appointed within those responsible parties to undertake training, to firstly enlighten themselves, enlighten their workforce, and more often than not, you'll find that the solutions to these compliance challenges posed by this legislation come from within. And that is really a very, very critical aspect. Then once you've actually established what you need to do, you need to apply internal measures to execute those steps. If it is determined that you need to review, for instance, your consent mechanisms, your client onboarding process, your employee agreements, your third-party data sharing agreements, whatever the case might be, you need to then practically take steps to execute the outcomes that your risk assessment has identified. And those execution steps really are going to be the manifestation of your overall compliance framework in the longer term. That's essentially, what Regulation 4 determines, and that's not the end. You cannot simply just give effect to those obligations in a piecemeal manner. This compliance journey is an ongoing process. You are going to also see, or we are going to see, this legislation develop. We do have the benefit of looking to other jurisdictions that have applied comparable legislation, in different jurisdictions. The GDPR is one critical example. But from a South African perspective, the Act or the provisions of POPI still do need to get tested. The Act needs to be applied, the Act needs to be enforced by the regulator, and we need to start building some sort of precedent which is going to enable us to understand, how the regulator deals with the provisions of the Act. So it's new legislation in the sense that, we need to see how it's going to get applied, and this is in all likelihood going to also shape the manner in which we provide services and we assist responsible parties to undertake this compliance journey and ultimately achieve and maintain a level of compliance which is acceptable to the regulator. With that said, in closing, I just want to very briefly deal with the steps which the Direct Marketing Association has taken in order to assist its members to achieve and maintain compliance. And really, that ultimately, or the vision of the Direct Marketing Association to assist its members, to guide them and provide them with access to the necessary expertise that will enable them to establish and maintain compliance is rooted in the development which was recently undertaken and launched by the Direct Marketing Association, which is its compliance portal. The Direct Marketing Association's compliance portal comprises of 3 elements. The first component is not new. It is actually an offering which Weavind Online and the Direct Marketing Association launched pursuant to its roadshow in 2019, which is the e-learning or the online training offering, which brings a comprehensive training intervention to its members that enables information officers within responsible parties and within organizations to really effectively deploy training interventions that enable their employees or their workforce to understand what this Act actually means, what it requires of them on various levels. That's the first component, is the e-learning platform. The second component is also an offering or a feature which was developed in partnership with Weavind Online as an alternative legal services provider, is to make available a cost-effective solution which enables members or non-members to obtain certain compliance documentation and to have that documentation delivered to them through essentially a tech-friendly platform that brings down the cost of deployment and also enhances the legal service experience, which is essentially the compliance portal's document generator, or POPIA toolkit as we refer to it. Essentially, there are 4 compliance documents that form part of that offering at this point in time. You are able to go and tailor and provide Weavind Online's legal team with the necessary information that enables our lawyers to sit and actually draft and prepare your privacy policy in the first instance, your PIA manual, secondly, thirdly, terms and conditions of use specifically for your digital interfaces like your website or your mobile applications, if that is applicable. And thirdly, which is the cornerstone of POPI, is consent. You need to procure consent from data subjects in order to process their data for specific and explicitly defined purposes. So we give you the necessary tools to be able to start your compliance journey and essentially procure that consent. So those documents or that package forms part of the second component of the compliance portal. The third component of the Direct Marketing Association's compliance portal essentially comprises of its so-called DPCP, the Direct Marketing Association's Data Protection Compliance Program. This offering is unique and proprietary to the DMA and essentially enables or affords members access to a self-paced, self-audit or risk assessment flow, which just simply assists that member or non-members, if that's the case, to understand what the Act requires of them, and also to help them understand what their compliance status is. Not that compliance in all instances has a definitive status, or that you are able to rubber stamp and achieve compliance overnight by completing a certain process or forming part of this program, but rather to really provide a value-added service and the necessary guidance which members would require in order to understand where they stand in terms of POPIA and what it requires of them. So essentially the DPCP is a series of questionnaires and a digital flow, which ultimately enables a member to self-assess what their compliance status is, given the fact that there's really only a very short period of time within which responsible parties should or can comply with POPIA. So the compliance portal overall houses these three features and essentially makes it available to members in a centralized environment and unlocks the user-friendly and necessary expertise that the Direct Marketing Association has surrounded itself with in a user-friendly, easy-to-use manner. So how do you get started? Where do you start? Essentially, you would need to go and create your account on the DPCP, on the DMASA's compliance portal. You would then, once having registered, be afforded a profile which will be activated, and once activated you will have access to the offerings that the compliance portal makes available to you. Like I said, essentially that comprises of the DMASA online learning portal, the DMASA's POPIA compliance toolkit, both of those offerings being supported and essentially provided in affiliation with Weavind Online as an alternative legal services provider. And then thirdly, of course, the DPCP component, which then enables a member to start the flow, complete the risk assessment, and get a much better understanding of why they need to take certain compliance steps. The questionnaires and the flow are very easy to use. You are prompted all the way through with certain notes and guidance throughout the flow. And ultimately, once you have completed that flow and those questionnaires, you will really be a lot closer to achieving overall compliance with, like I said previously, this game-changing piece of legislation. So essentially, the compliance portal is the Direct Marketing Association's investment into its members. The offering is unique, it is innovative, and it is really easy to use. We encourage you to do so. And of course, you are always welcome to contact us. We are at hand to be able to assist you, to assist the DMASA's members, and to really help you as responsible parties to firstly achieve compliance, and then ultimately you need to maintain that level of compliance on an ongoing basis. So this is an interesting time, I think, nationally, globally, and with the value of data on the increase, it's becoming all the more important for you to appreciate that, understand that, and then get your house in order. Make sure that you take the necessary steps that you can in order to achieve compliance and really process data responsibly. Make sure that your reputation isn't put at risk and that you are in a position to safeguard the personal information which you are the custodian of from time to time. With that said, I'd like to thank you for your time. It would be a pleasure to see you next year face to face. But thank you very much for giving us this opportunity. I'd like to thank David and his team yet again. It really is always a pleasure and an honor for us to be a part of innovative, exciting solutions like this. And we look forward to engaging with you. Thank you very much.